choose. Recorded live.
I'd like to welcome everyone to this Wednesday, February 26, 2014 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. Welcome to the study of equity. Welcome to the revival of the study of equity, its principles, doctrines, and rules of equity in opposition to the tendency giving an undue prominence and superiority to purely legal rules and ignoring, forgetting, or the suppression of equitable notions. And welcome to a crier in the wilderness, hear ye, God's court is now in session, for repent, for the Lord's kingdom and its enforcement is near. We left off on section 1072 in Pomeroy's Equity Jurisprudence, Volume 3. That's section 1072. That's on page 364 in the PDF or page 2457 in the book. That's section 1072. So take notice and acknowledgement with agreement that this show under documents is a private confidential arrangement not to be construed or relied upon as being legal advice for an individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show under documents are for economic and informational purposes only to be used at your own risk without liability to Christian Walters. By accessing and reviewing this show or using the documents therein, you understand with your agreement that with all rights reserved without prejudice, Christian Walters is not an attorney to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, providing no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in preparation or use of herein reference. Has no interest in any use referenced therein, is not a party to this or any action arising from, and is only acting as an authorized capacity as liaisons of communications between the parties. By reading or using this information, you acknowledge and agree you are not a client of Christian Walters. These documents and their show recordings are incomplete and void without this notice of agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for commercial damages of $200 million or more per stultification or impairment, per Christian Walters' discretion. Thank you for your understanding. Now let's move on to what a definition of equity is, and that takes me to my most favorite quote, John Bouvier, out of Institutes of American Law, 1882, Volume 2, Section 3724, Paragraph 4, which states that law is nothing without equity, and equity is everything, even without law. And those who perceive what is just and what is unjust only through the eyes of equity, or only through the eyes of law, never see as well as those who behold it with the eyes of equity. Law may be looked upon in some manner as an assistance for those who have weak perception of right and wrong, in the same way that optical glasses are useful for those who are short-sighted whose visual organs are deficient. Equity, in its true and genuine meaning, is the soul and spirit of the law. Positive law is construed, and rational law is made by it. John Bouvier, Institutes of American Law, 1882, Volume 2, Section 3724, Paragraph 4. Basically what it says is that equity creates all laws. It is the soul and spirit of all law. If it's the law that's written on your heart, it is the only one and true law, and all the other statutes and codes and jurisdictions all fall under as judgment for not doing the equity. supposed to be looked upon in some manner as an assistant for those who have weak perception of right and wrong. Well, there's where we're off at. We don't know the difference between what's right and what's wrong, or what's equitable and what's not equitable. We don't understand what love is. Because equity is supposed to be administering love. Treat your neighbor with love. Do unto others as you have them do to you. That's the equitable principle. He who comes into equity must be doing equity. That's Matthew 7:12. Righteousness, righteous living. That's an equitable life. And that's what the Garden of Eden was all about. Equity. An equitable life. A perfect Garden of Eden. And are we perfecting equity in our lives today to bring the Garden of Eden and manifest it in our lives today? Do we love our brothers as ourselves? And all humanity is our brother. It's got nothing to do with race. It's not blacks, whites, yellows, reds. Nothing to do with that. They all bleed the same color blood. They're all human. All from one atom. That makes us all brothers. And that's the way we need to look at it. We need to treat our brothers with love. And he who comes into equity treating their brothers as love then has a right to ask equity to be done for them. If you don't, you have a mind of confusion. You're not worshiping the right God. But these are the optical glasses you need to put on because you're short-sighted. Your visual organs are deficient, and you don't really understand what the law really is. Because the law consists of 9/10 equity in its principles and the 1/10 enforcement or the judgment of not doing the 9/10. And that law consists of the 9/10 and the 1/10 together. That is the whole law. That's its true and genuine meaning. That is the soul and spirit of the law. Spirit of the law, that's equity. The soul is probably, you make reference to that as being, say, statutes and codes or the 10 Commandments. The principle or the soul, the spirit of the law is equity, the 9/10. The underwater part of the iceberg that you don't see. The 1/10 part up above the water that you do see. Statutes and codes, 10 Commandments, common law, whatever you want to call it. All the same thing. 9/10 down below, it's only one thing, equity. What is your 1/10 resting on? The 9/10. The 9/10 foundation, the soul and spirit. So it doesn't matter how many people don't believe it. What matters is whether it's true or not. And what is truth? And now public versus private definition. People don't understand what's private, public. They're all confused. Private is any relation that you apply or express which is your intent as a special one. And the next question I always ask would be, when did you ever express your intent to form any relation as a special one? Because you just can't say, oh, this is a special relation. No, it doesn't work that way. And then, consequently, then all your relations are all public. You just don't know it. You didn't do something special. And that special is about NTT. That's how we form a special relation, through the knowledge of NTT, New Trust Technology. It has to be done in a very particular way to make it special. It has to be exceptional. So the doctrine of election comes in. If you had two realms, public and private, or one special and one not special, the one that you choose excludes the other on a multiple choice. Check Section 463 in Pomeroy. doctrine of election. The one that you will choose substitutes for all the others. So now, intent. Intent is probably the key thing. So how do you prove intent? Well, it's the manifestation of intention that controls. Now, that's out of the LGVA case, out of Courts of Special Appeals of Maryland, 2011 case. LGVA versus Belvedere Farms says it is to be noticed that an express trust may arise even though the parties in their own minds did not intend to create a trust. It is the manifestation of intention that controls and not the actual intention, or that differs from the manifestation of intention. An express trust may be created even though the parties do not call it a trust and even though they do not understand precisely what a trust is. It is sufficient of what they appear to have in mind as in its essentials what the courts mean when they speak of a trust. How many trusts are out there that you have created that you're not even aware of that was your intention to create a trust? Although you've demonstrated your intention by the manifestation of records, and that's what controls. Do you have the records to prove it's a trust? Probably not. So what records are out there then? Oh, birth certificate, social security card, driver's license, voter registration, contracts. So what records have you manifested? What jurisdiction have you manifested? Oh, D.C. realm. Remember, it's the records that controls, proves your manifestation. Without the records to prove that you formed a special relation, then whatever records that you have brought forward manifest that jurisdiction. And when did you ever create any records to create a trust? All you have is D.C. contracts, driver's license, birth certificate, all these documents to prove that you are that stinking fiction. But trouble is that fiction doesn't stink if you know how to operate it. You just get in it like a little kid and wreck it, and then you think it stinks. You just don't know what makes it go and how to make it go the right way. Now on to Adams' quote out of The Origin of English Equity. Adams wrote, "We may confidently assert that equity and common law originated in one and the same procedure, that during the first 200 years of their history, they were not distinguished from one another." So there they were, commingled, and everybody thought that they're one. Here's this fair, just, and right that everybody wants. And here, that by definition is the equity part of this commingled confusion in our minds and understanding. And we think that's common law. And here's not common law. Common law is separate. Equity created common law. Here, the fair, just, and right was equity. Equity creates common law. Equity creates admiralty. Equity creates civil code. Equity creates all so-called law, but all those laws that it creates are really in the jurisdictions, whatever they are, whatever forum, they are just the enforcement of not doing an equitable living. In the same way that optical glasses are useful for those who are really blind and can't see the difference and perceive what's right and wrong. You've got to put on the eyes of equity. It says that during the first 200 years of their history, they were not distinguished from one another, and that if we do it now, distinguish between them during the periods we do it artificially by the application of tests impossible to contemporaries. It's well on to the 14th century before we get any clear distinction between equity and common law. Because back then, when the 1500s, the 14th century, they finally figured out that equity was distinct from common law. And I think that the courts understand that, at least the upper courts. They know equity is running the whole show. They themselves are operating the courts equitably. We just don't know that it's equity. And until you get the equity eyes, you're blind. You see the law differently. But when you get equity eyes on, you will see the law even different, more different yet. You will see the law for what it truly is. Equity always follows the law. Well, what's the law that it follows? Equity follows itself. And unless the jurisdictions that it creates, the judgments that it administers out of those jurisdictions, unless they're equitable in their principles, then they're not laws. And they should be stricken. It comes down to the codes, say the statutes and codes. Do they reflect in their writing equity? Depends how you look at it. From what side are you looking at that jurisdiction from? Because probably from the at-law side, you probably can't recognize any equity, which is really wrong because it's all one jurisdiction. The foundation, there should only be one jurisdiction, really. Equity jurisdiction, period. Common law, admiralty, civil law, all that stuff, you could take and abolish it all. Only you need one jurisdiction, equity jurisdiction. It is so flexible in its application to anything. Criminal, non-criminal, civil, private, public, whatever you want to call it, there should only be one foundation of law. A monotheistic society based on the principles that God puts forward, the maxims of equity. Hear, O Israel, hear, the Lord thy God is one. There aren't multiple jurisdictions in God's realm, and there shouldn't be any multiple jurisdictions in here either. We left off on section 1072, talking about the duties of express trustees. 1072 is the necessity of making investments. It is the trustee's imperative duty to render the trust property as productive as possible, consistent with this, it has security with the demands of ordinary business, prudence, and judgment. The rule is general, therefore, that if he permits the money to remain in his own hands unproductive for a period under the circumstances is unreasonable, then he will be personally chargeable with a lawful interest which might and should have been obtained by the exercise of reasonable care and diligence. And if the principal fund should be wholly or partially lost in consequence of such unreasonable delay, he will be compelled to make up the deficiency. Even when the instrument creating the trust prescribes a particular mode of investment, as, for example, it directs that all the personal property should be converted into cash and the proceeds invested in the purchase of land, the trustee cannot be justified in suffering the cash to lie idle and unproductive for an unreasonable length of time. Footnote 1A. Case cites to support that. It says if a trustee permits trust money to remain on deposit in a bank or in the hands of a third person for an unreasonable time, he is responsible for any loss. Case cites to support. Back in the text, next section, 1073, kinds of investments when particular securities are expressly authorized. There are two cases to be considered. One, the instrument creating the trust expressly authorizes investments in particular securities or directs particular modes of investment. And two, when the instrument is wholly silent with respect to the mode of investment and the manner is left to the judgment of the trustee. In other words, he was granted broad powers. Nothing specifically, just plain old broad powers. So let's say in 1933 the country went bankrupt and everybody gave up their physical rights and converted and put them all in special deposit along with their gold and their silver and all their collateral. And what was left was the human resource, which is represented by the birth certificate. And as soon as the birth certificate was brought into existence based on a real being or a live birth, then the actuary tables were looked up and finding out how much it's going to be worth in his total lifetime starting at that particular date. And that amount of money is created and put into trust and as a derivative based upon that birth certificate, and it's put into circulation for the benefit of all the people. We have a system of fiat currency based on the signature on the birth certificate. That is the money. And what does that represent? That represents your life, your time in your life. And that money was created for you and others as co-beneficiaries for the purpose of you conducting your affairs of your life so that you would have enough money to transact whatever you needed to transact. But here's the thing. That's all a playpen because you're incompetent, because you're doing commerce. And you don't know you shouldn't be in here, and you shouldn't be doing commerce, and it's a temporary holding pen, and you're in this temporary holding pen, this parent parentis is over you, the state, taking care of you like a little child, and you're 40, 50, 60, 70 years old because you've been given just enough to exist on, thinking that you're making a lot of money working, and here everything really is free. Now, how is it free? Well, we go way back when the earth was created and man came about. God didn't say to Adam, well, Adam, I want you to take care of the earth and work in the garden for $6.95 an hour. No, he gave Adam the land to use and possess for free. And everything that Adam would take out of the ground, or anybody who followed after Adam as descendants of Adam, taking anything out of the ground and changing its form into something else, like an automobile, a cell phone, plastic tube, a TV, electric lamp, whatever it might be, it all came from the ground. And you didn't own the ground. You had the free use and possession of it. It was freely given to you. In fact, your life itself came from the ground and was a gift from God, and that life was freely given to you. And are you freely giving as you freely received? Because isn't that the commandment in the Bible? Freely you have received, freely give. But do we do that? No, we charge commercially. That puts you in the playpen until you realize that everything really is free. As God give it to you free, you got to give it to others freely. We need to take on the responsibility of creating something and imitating God, because Creator is the Creator in heaven. He creates things. What are we creating? Anarchy. Confusion. We're creating commerce. That's a thing of man. Jesus threw the temple, money changers out of the temple for doing commerce in my Father's house. There is no commerce done in heaven. And when we bring heaven to earth and manifest it as in heaven as on earth, when we manifest it on earth, then we duplicate what's in heaven, and there's no commercial transactions in heaven. So why are we doing them here? Why aren't we mimicking God? Why aren't we little chips off the old block? We're made in His image and likeness. Why aren't we imitating Him like Ephesians 5:1? Be imitators of God. Why aren't we manifesting the kingdom? And that being demonstrated by a record of our deeds. So that we can untie the hands of God for Him to bless us. Seek first the kingdom of righteousness, and all things will be given to you. Righteousness is the same meaning in the Greek as the definition in the Old Testament as to equity. And equity means what's fair, just, and right. So it says righteousness. Seek first the kingdom of God and all His righteousness. In other words, seek first the kingdom of God and all His equity. He who comes into equity must be doing equity. He who comes into equity must be doing righteousness. Righteousness and sanctification and a sanctified living. Of course, it also helps to be justified first, because justification is just one dimension of salvation. The first dimension, past tense. If you're a believer, is by faith alone in what Christ did, His cross work. Then after you've been justified, you immediately go into the second dimension, which is the present tense, which is the now that you live in. And then it depends upon your works, your deeds, your actions, whether or not you manifest the kingdom. And how well you do that is rewarded in heaven for eternity. But in case you can't do it because you're living like the devil, when you die, Christ will finish the work for you. But you may be the ground pounder in heaven and wailing and gnashing of teeth, because you'll finally realize that you could have been a higher position. You could have had more rewards. You could have had more fellowship time with Christ. You'll be saying that for eternity you're stuck in a position that you could have bettered yourself on the regular 75 years of your living in a sanctified life, but yet you lived like the devil. And you just blamed everybody for your situation, which is the Adamic flu. Adam and Eve, first thing they did was they blamed everybody. Blamed Satan, blamed each other, blamed God. That was the first thing that they caught from the sin problem. They caught the Adamic flu, blame shifting. And that's what we do. Oh, those darn judges. Courts suck. The judges are all treasonous. No, they're not. You're the problem. You got the wrong understanding. Used to think that way myself, but back then I didn't have equity eyes. Put on the equity eyes and you will see things differently, because the veil that's over your eyes will be lifted and you will see the truth for what it is. The problem is today it's us. Lack of responsibility, apathy, blame shifting. We're perishing for lack of knowledge. What's that tell you? Hosea 4:6. What's the lack of knowledge that we're perishing from? Equity. How to lead equitable lives. Do we manifest that in our lives today? Or are we going by the commercial sense, working 40 hours, and we don't have enough time to do anything other than play because we want to relax? Sit down, drink a beer in front of the TV. Go out and listen to some music. If we even have enough energy to do that, after what today is, working for 60 hours just to scratch and make ends meet, because you're in a commerce world that you shouldn't be in. The worship of money, the golden calf, that's one of our major problems. That's one of the major things that the scriptures talk about, the worship of gold, the mammon. Either you'll worship one and hate the other, or vice versa. Choose which God you're going to serve this day. Repent, for the kingdom of God and its enforcement is near. The establishment has already taken place the last time He died on the cross. Equity looks forward. It's already being done. To Telestai, it is finished. It's just all waiting for the enforcement of the kingdom. The kingdom's already been established. Equity's been established in God's mind since before the foundations of creation. Back into the text. Number 2, when the instrument is wholly silent with respect to the mode of investment and the matter is left to the judgment of the trustee. In the first case, when the instrument itself directs the mode and nature of the investment and designates the securities, the trustee is bound to follow these directions with scrupulous care. If any loss of trust property is a result of his obedience, he is not at all responsible. A departure from the directions will entail liability for the losses which he may occasion thereby. Even when the general discretion of the choice of securities is expressly given, it must be exercised with reasonable care and business prudence. Next section, 1074. The same, when no directions are given. That sounds like the way the birth certificate is. You granted the person and created the authorization to print the birth certificate, which is the certificate or the shadow title, which represents the ownership to the thing, the res, the baby. You say, well, like, how could I sign anything, back then? Well, your mother, on behalf of you, working on your behalf, did what she did. And you say, well, that's not me. Well, I'm afraid so, because when you just never realized what was done. But remember the LGVA case. The manifestation of the intentions, what controls, not whether you intended the actual intention or not. You say, hey, that's not me. Well, what records do you have to prove that it is you? Birth certificate, driver's license, Social Security card, all these things that you signed, you applied for. But these things aren't so bad if you know how to use them. If you knew what the real substance was, because these are just shadow titles representing the real thing. And they're part of you. If you want to leave them, it's like cutting off your right arm and your right leg. Leave those behind. The certificates of titles represents you. Oh, I'm not that stinking fiction. I'm afraid so you are. You've just taken a Ferrari and wrecked it. And you don't want to admit it's got dented fenders all over. Oh, that's not me. I didn't do it. You want out of your obligations that you set up, even though they are DC. Scripture says, let your yea be yea, your nay be nay. Didn't you put your word on there? On that contract? Now, I'll say that the contract was unconscionable. I mean, who was in their right mind waive their equities? And that's what usually these contracts say, that you waive all your equities. You got to be incompetent. You got to be a ward to say that. And you are. If you were in your right mind, you would never sign that contract. You would renegotiate it somehow. But you waive. You establish a monopoly. You allow them to dictate to you. If you've known how to do it, you could have got a private agreement. Been on another decisional law other than, say, your state decisional law. And what that might be. Equitable principles instead of the narrow interpretation of the statutes. Under the broad interpretation, equity, versus the narrow interpretation, the statutes of enforcement with no equitable principles in them. You know what the conflict is? The conflict is that there is no statute and code today written that explains the equitable content of the statute, if there is any, because that explanation is in the annotated version of the statute, and the annotated version is not supposed to be part of the codified version. But if you compare the two and its explanation, when you read the annotated tells you all about this equitable substance, but yet it's not mentioned in the code itself. That's a conflict. That's a bingo. The conflict is that the statute itself does not reflect the equitable understanding in itself. It has to be explained by something that's not codified, the annotated. The annotated is not the written statute. Therefore, it can be interpreted which way. But when you read the annotated, it gives the explanation of the equity that should be there, but it's not because it's not in the statute. It's on a separate location in another book, another writing. That demonstrates written and unwritten. It's the unwritten that you want, because the unwritten, the annotated, tells you about the fair, just, and right. That's the broad interpretation. The narrow interpretation is where the statute itself is narrowly construed to be the literal meaning of the statute, or the narrow interpretation, without the substance, usually, which is in the annotated. So, with them being separated like that, that's conflict, because the meaning of the statute that's written is really in the unwritten, although it's written in annotated, and they function as one. That's the real law. The real law is the statute and the annotated, because the meaning is in the annotated of what the statute, the code says or means. But now, you're supposed to know that, but the laws should be written so that any prudent man could understand them. That's a conflict, because they're not. How many people know about the annotated? What's that? Where do I find that at? Is that readily available so that any prudent man can see what it is? Where did we leave off at? 1074, the same. No directions are given. Where the instrument of a trust is silent as to the mode of investment, the rules governing the action of trustees may appear to be somewhat arbitrary, but are in reality based upon the clearest principles of justice and expediency. The law does not give to trustees the same freedom of choice in investments which he may exercise by prudent businessmen in their own affairs. A businessman of even more than average caution may and often does assume intentional risk in the investment of his own property for the sake of obtaining a greater than ordinary income. He will often invest in such manner as the risk of ultimate loss is considerable, and such speculative use of the property would not be regarded as illegitimate nor as deserving of any censure. For example, he may invest the stocks of the companies which promise with good fortune may pay large dividends, but which he also may utterly fail. No such risk is permitted to a trustee. In the management and investment of trust property for the benefit of said key trust, the law, while requiring some income, regards the security of the fund invested and the certainty of a moderate regular income as of paramount, of absolutely essential importance when compared to the amount of the income. It permits the trustee to assume no risk in his investment other than those which were inseparable from every species of property. Absolute freedom from risk is impossible. The most stable form of property may lose their value, lands may depreciate, and even nations may become bankrupt. And from these risks, which inhere in every kind of ownership, the law does not pretend to save the beneficiary, but from risk grown out of the uncertainty of speculative investments, the law does protect him from making the trustee personally responsible for all trust funds invested by him in such a manner. Brings into mind the parable of the talents, where the one stuck the coin in the ground. He didn't make any effort to invest it as a prudent man would. The other two were prudent, and they got a return, and they increased their wealth. Back in the text, it settled rule of equity in the absence of express directions in the instrument creating the trust or of statutory permission, that trustees or executors cannot invest trust property upon any mere personal security, nor upon the stock, bonds, or other securities of private business corporations. Where no directions are given by the instrument of trust, the well-settled rule of English courts of equity is that the trustee should invest trust funds and can only escape personal risk and liability by investing in real estate securities or in public governmental securities of the British government. Footnote 2. This investment in municipal bonds or in the government stocks, bonds, or funds of foreign countries, or in the stocks and bonds of corporations is never directed by the court nor permitted in the absence of authority given by the instrument of trust. Case cites to support. Back in the text. In the United States, while the rules are certainly not so stringent and invariable as in England, and while different regulations may prevail to some extent in different states, based partially upon statutory legislation and partially upon policy of encouraging local enterprise, the same fundamental principle of requiring permanent investments in real estate or governmental securities is generally recognized by the courts. At least all speculative risks are forbidden. Footnote 3. As the action of American courts can best be illustrated by the facts of a few very recent and instructive decisions. In Adair versus Brimmer, the subject was examined in the most amiable and exhaustive manner, and the trustees were sternly held up to their duty. A testator had given an enormous estate to 3 trustees with the power to sell lands and in the direction to invest the proceeds. Among the lands that was a large tract of undeveloped coal land in Pennsylvania, of which the testators owned one. Let's see, I can't see what that word is. Prints off. It looks like subdivided third, and other 2/3 being owned by M&N, and the entire tract being worth from $1 million to $1,400,000. The trustees conveyed their 1/3 to M&N, and nominally for the price of $250,000. The sale was really made to enable M&N to organize a mining company, and the land was immediately conveyed by them to the company. The stock of the company was issued, and the trustees took such stock as par value in the amount of $250,000 in the consideration of the sale of the land. The company went on to develop the coal mines and was compelled to borrow money, and to that end it issued its bonds for several $100,000, which the stockholders were obliged to take pro rata, and the trustees thus took a large amount of the said bonds as security for money advanced to them to the company. The stock and the bonds became worthless, so that the coal land had, in fact, been totally lost to the trust estate. And in the final accounting, the trustees claimed that they were entitled to be credited with $250,000 in stock with the amount of the company bonds which they had taken. The court held that the trustees had grossly violated their duty, and they had no right to sell the land for such a speculative purpose. The power given them will be in the will to sell only authorize them to sell the purpose of carrying out the general objects of the trust and of the making the property certainly productive for the beneficiaries. Furthermore, they had no authority to invest the proceeds in such securities as the company's stock and bonds, and they were to be charged with the market value of the land at the time of the sale and with interest thereupon at 6% computed with annual rest. The trustees having set up acquaintances with the beneficiaries in defense, it was further held that the acquaintance or assent of the beneficiaries so as to relieve the trustee could only avail when given after a full knowledge of all facts and the full understanding of all the beneficiaries' own rights and the matter, and any assent given in the absence of such full knowledge and understanding was of no effect. And there's another case, King versus Talbot. Check that one out, going back into the text. Back into the text. Investments and first mortgages of improved land are universally favored, and the trustee is not liable for any subsequent depreciation of value if the original security was sufficient. Indeed, investments of this form are generally required to be made by public officials of trust money paid into court. The investments in second or subsequent mortgages would be at trustee's own peril. Trustees may also always invest the governmental securities of the state under whose jurisdiction they are, and in those of the United States, and perhaps an investment in the public securities in other states of the Union in which the credit is firmly established and may be permitted. But any greater extent than this, investments in foreign securities are a violation of trustee's duty. You know, even Pomeroy is not quite right on some things because of his applications for commercial purposes. But yet that points out how universally equity is in flexibility to apply to any particular situation. So the commercial sense of the application of equity is again in violation of kingdom principles, because money changing, because the ground is free and everything comes from the ground. And those things that you're taking from the ground and you're buying and selling are in violation of the kingdom. And the kingdom is equity. I can see no use for money. Money is a man-made, contrived by man, used for the purpose of enslavement. It's really a millstone around your neck. But it has to be, because that's temporary holding pen. That's the public. And the public operates solely on commercial. So you have to come to the understanding that there's no need for commerce. There's no need to apply equity in commerce. We need to go back to a free system, and only there will everybody be equal. It's not based on economics. It's not based on free trade. It's not free trade. If you're trading, it's not free. That's a misnomer. That's a lie. Free trade. There's no such thing as free trade. But the wordsmithing and the understanding comes down to, its application, meaning as being defined in application to a jurisdiction, a commercial jurisdiction, or a non-commercial, say, equitable jurisdiction or kingdom. But I know Satan takes and always counters everything God does. God comes up with a free kingdom. Satan comes up with one, he enslaves everybody by money. Now, that doesn't mean that we don't use money for righteous purposes, if necessary. But why would you want to call it money? I can only think of one way that I would want to use money. That's if we couldn't ship something to some place, halfway around the world on the other side, that by the time it got there, it would perish. But even in today's age, we could even do that overnight. You could fly something over there before it perished. We could preserve it, say like food. We could feed the starving people around the world overnight. We just don't do it because of commercial transactions. It doesn't pay to do that. so we let people die. Isn't that kind of like leaving the ox in the pit because it's the Sabbath? Because the law says the Sabbath you can't do any work? And if the ox falls into the pit on the Sabbath, you've got to leave it in there? Isn't that kind of like throwing the baby out with the bathwater? Here we have people dying on the other side of the world that we could feed, and we got grain rotting in silos someplace else. So we convert some kind of asset here into money, and we send the money down there that they could purchase food in their locality. But yet that probably wouldn't work either because they don't have any food in any locality close by. So what really needs to be done? We need to transfer to them, give them the technology, the knowledge, the equipment that they need to grow their own food. And that way, I don't need to feed them. They can feed themselves. You know, that's probably the best education anyone can get. When a teacher teaches you how to fish, you can fish for the rest of your life. Otherwise, I have to feed you a fish daily. And the greatest gift to you is to teach you how to fish so you can feed yourself. And then you could be a blessing to others and teach them how to fish and give them fish until they learn to fish for themselves. Back into the text. In some of the states, statutes permit investments in municipal bonds of cities, countries, and towns of state within those jurisdiction and trustee acts. Whenever the principles of equity jurisprudence have been fully accepted by the courts, trustees are not allowed to invest in the stocks, bonds, and other securities of private corporations, and certainly not without a statutory permission. Such unauthorized investments do not ipso facto render the trustees personally liable, where no loss ensues, but if any loss results, they must make it good. Where, however, the trust provides for a transfer of the property to the beneficiaries, they are not bound to accept such unauthorized securities from the trustee, even though those securities are not at all depreciated in value. It should be carefully observed in this connection that if the beneficiary is sui juris and competent to bind himself, his consent to the irregular investment would be a justification of the trustee's action and a waiver of all claim against him for resulting loss. Next section, 1075. Number 3, to act with good faith, which breaks down to, number 1, the duty not to deal with trust property for his own advantage. States that the absolute most scrupulous good faith is the very essence of the trustee's obligation. The first and principal duty arising from a fiduciary relation is to act in all matters of the trust wholly for the benefit of the beneficiary. The trustee is not permitted to manage the affairs of the trust or to deal with trust property so as to gain any advantage, directly or indirectly, for himself beyond his lawful compensation. The equitable rules which govern the personal dealings between trustees and all other fiduciaries and their beneficiaries, their contracts, purchases, gifts, and the like, have already been examined, and the branch of the general obligation and use good faith needs no further discussion. And I would say, of all the trust assets that the trustees today are taking care of, they're doing a very good job of it because those assets are still there. They're still there waiting for the beneficiary to wake up and realize who he is, the beneficiary. And until he grows up and becomes competent of who he is, beneficiary, then his welfare and maintenance and education will be just the minimal. And until you figure out that you're the beneficiary running the whole show and the whole thing is for you, then you will up your ante, your maintenance, and your welfare. and then you'll get off the treadmill of commerce. You'll get out of the public, in a sense, and you'll be operating in the private. The true private that everybody wants to be in is in the kingdom that operates under kingdom principles, and that's equity. That's God's kingdom. And that's through Jesus Christ. Back in the text, it is equally imperative upon the trustee in his dealings with trust property not to use it in his own private business, not to make any incidental profits for himself in its management, and not to acquire any pecuniary gains from his fiduciary position. The beneficiary is entitled to claim all advantage actually gained and to hold the trustee chargeable for all losses in any way happening for a violation of his duty. Let's see footnote 2, ante section 955 through 965. Next section, 1076. Number 2, the duty not to mingle trust funds with his own funds. The second important duty of good faith includes not only the intentional use of trust funds in the trustee's own business, it prohibits the mixing of the two funds together in one amount, the depositing trust monies in his own personal account with his own money in a bank, borrowing trust funds or going through the form of borrowing for his own use, mingling receipts and payments of trust monies and his own monies in books of account, and all similar modes of combining or failing to distinguish between the two funds. The trustee may not thus mingle trust monies with his own, even though he eventually accounts for the whole and nothing is lost. The rule is designed to protect the trustee from temptation and from the hazards of loss and being a possible defaulter. When the trustee does mingle trust funds with his own, the right and lien of the beneficiary attached to the entire combined fund as security for all that actually belongs to the trust estate. A violation of this duty subjects the trustee to the following liabilities. Number 1, if the mingling is followed by actual loss, accidental or otherwise, the trustee must make good the principal sum lost, together with interest and perhaps compound interest. Number 2, where there's been no positive loss, but the whole fund's principal, profits, and proceeds are in the trustee's hands in their mingled condition, the burden of proof rests upon him of showing most conclusively what portion is his, and whatever of the mixed funds included both profits and principal, he cannot thus show to be his own, even though his whole mass will be awarded to the beneficiary. The beneficiary is always entitled to claim and receive the actual profits when they can be ascertained. And number 3, if it is difficult to distinguish the funds so as to tell the amounts of profits or proceeds which is the beneficiary's share, the court may not only require the trustee to restore the principal which he has appropriated, but in place of the profits may compel him to pay interest compounded with rest annual or semi-annual or even more frequent as the extent of bad faith may seem to demand. And 4, even if the trustee voluntarily accounts for and restores all the principal that he has mingled with his own, the court will at all event charge him with interest thereon. Okay, 1077 next. I think we'll pick up there next time. That's number 3, the duty not to accept any position or enter into any relation or do any act inconsistent with the interests of the beneficiary. 1077, we'll pick up there next time. That's on page 380 in the PDF or page 2473 in the book. That's section 1077. We'll pick up there next time. So let's go to Q&A. Anybody have a question? Press star 8 to raise your hand and get in a queue line. Press star 8 to raise your hand and get in a queue line. Star 8 to raise your hand, ask a question, get in the queue line, star 8. State your name, where you're from. Any questions? Star 8. Star 8, anybody? Question? Question, anybody? Star 8. Star 8, question?
Hello?
Yes, who's this?
Hey, CW, how you doing? This is Tyrone.
Hi, Tyrone. How you
Hey,
doing?
I'm blessed. I'm blessed. I'm blessed. Wanted to kind of give you a hypothetical situation that happened to me on Monday. Had a court date in federal court. Never been in there hypothetically, so it was a new experience. And the judge pretty much hammered me for 35 to 45 minutes straight. And what he was basically saying is that I had no clue what in the world I was doing. But what I did, and I thank God for it, I came in low. I wasn't argumentative. I was basically saying that, I just need, I'm just trying to do a equity here. I was using equity maxims. And by the end of the 40-minute rant that the judge was doing, he started to help me, which, I didn't expect that. But, he kind of walked me through what I needed to do, how I needed to say it. He told me I could amend my complaint now this was after he said that he ruled against me. But I just kept sticking to equity, and he said, well, you could just, amend your complaint. This is what I need to see, and this is what it needs to look like. And it blew me away.
That's awesome, really.
I mean, he started to help me.
You untied his hands.
I didn't come in arguing. I didn't come in saying that I knew what I was doing. I basically said, this is my first time. And I just kept using equity. And, I also filed a pauper's oath. And, I told him I wasn't receiving any income. He challenged that. He said, well, how are you paying your bills? I said, by the grace of God. And he sat back in his chair. So he continued to help me. Now,
Did he grant their paupers?
Yeah.
Yeah, he did.
That's why he told me, because if he didn't grant that, then the complaint wouldn't be able to move forward.
Right.
So he granted that, and he told me how to amend it and what I needed to do, and it was just a real blessing. It was a real blessing.
How did he go about telling you? What did he tell you? What were you lacking? What were you lacking?
I was lacking the details of the story. So he walked me through it, and you said it many a times. I had the jurisdiction, I had the venue, I had the actual the factual allegations. I had it all set up. I took it out of Gibson's, the setup of it. Gibson's and Strong's, federal forms. And what I lacked, I made an allegation, and I said the defendant willfully done something.
Without the merits.
Without the merit. So,
and the merits are the facts of the case, and the facts of the case are really the SOIs.
Right. And so I added like 6 merits of the case. On such and such a date, I sent a notice to the defendant, on such and such a date, they did not respond. On such and such a date, I sent a second notice. On such and such a date, I defaulted them. And then on such and such a date, I gave them an opportunity to cure. So those are the merits of the complaint. But the only thing that the first time I put in there, I just told them what they did.
And then how is that presented? In what form?
Help me out. I don't understand what you mean. What form?
How did you convey that? How would you convey that? What form would you put it on? What would it be called?
With the amended complaint?
Yeah, but it's also got to have something in support, though. What's the supporting document called?
Oh, the affidavit.
Affidavit.
Yes, sir. Yes, sir.
So, what is the affidavit?
The affidavit is basically saying that I am attesting under penalty and perjury, under oath, that what I said in the complaint is true to the best of my knowledge.
So you're turning your complaint into an SOI.
Yeah,
and the affidavit is pointing to the real live man who can give testimony and prove the facts by live cross-examination if necessary.
And the NTT way is that is the second witness, the actual affidavit. So I mean, the whole experience.
One SOI is you giving testimony on such and such a thing that happened, and then you need another SOI. You need two records, one SOI and another record, an SOI. You need two records to prove a fact. So one would be your testimony, an affidavit saying that everything you put in the pleading was, your testimony. And then what would the other record be that you would need?
The actual the proof of
Well, what are you claiming on such and such a date? What?
Right, the proof of that I sent something and they received it, the green cards
or something like that. Yes.
Yeah.
But now you got two records to back up your statements, and that's what the judge wants.
Yes, sir. I'm going to tell you something, CW. It's really, really, really been a blessing to be a part of this study. I'm starting to understand what you've been saying from the beginning. I guess it took me a long time.
What do I usually say? NOI, SOI?
Right, but, to actually do it and have the judge walk you through it, I mean, it was eye-opening for me. It was for me, it was a light switch to go on because it works like that with everything. If you send them a notice and they never respond, whatever you put in that notice becomes fact.
After it's been cross-examined, it becomes fact then.
Because they can't deny that it was sent. And if you're being equitable, you make sure you send a second one, just to be sure. And then you send them another notice of default.
Yeah, that's what NTT is all about, showing you how to create records and how to move the records, which are titles. And as long as you've got two titles or more to prove a fact and you've moved them in the right place, then it's just like putting pegs in the right holes. It's like, that little game you used to play on the triangle, and they got those pegs in it, and you jump like checkers in a way, but it's got the golf tees in them.
Yeah, that's they usually have that Cracker Barrel.
Yeah, it's just like that. You got all the right holes with the right pegs, then you can do the right moves.
Well, I'm not ashamed to say, you've been saying that to you that have been blue in the face.
It's all about moving title. The moving title principles. How to create a record, a title, and how to move it. And how to make it into an SOI, and how to include it with an NOI, a claim, and then how to present it in a jurisdiction that you can get adjudicated.
I get it now.
And all this is NTT. And NTT rests in new trust as in equity, and equity reflects the God-conscious mind. Amen.
Amen. I appreciate it. You know, even with dealing with the deed of trust and housing, it works the exact same way.
Let him who has ears, let him hear.
If you have the records, how can someone dispute you if they never answered it? I just wanted to say thank you, because I really, really get it now. The fact, you know, dealing with biblical principles and dealing with God, two witnesses, the court will become your advocate if you create the records. I'm a witness because I didn't know what the heck I was doing, but I had the intent and I had the study behind me, so he knew that I was studying. I just didn't understand quite how to put it all together.
Yeah, some of the form, process, and procedure may be missing, but Gibson's pretty much, you know, put that together. But then you could be on reliance on your court rules that you have to go by that too. But it's all there. It's all there. It just takes time. There's no fine wine without time. It takes a study.
What I will say, in that 35 to 40-minute rant that the judge was doing, he was really disturbed, as I could hear it in his voice, about how people come into the court and have other people write up their forms or documents or pleadings, and then he asks them questions about it, and they can't answer anything.
Yep, that's the problem. They're incompetent. They're in a dire strait, they're in an emergency situation, and they need to know something, and they're perishing for a lack of knowledge, and they can't get it now overnight. And they haven't been studying this stuff, and they don't think it's important. But somewhere in your life, you're going to come up with a situation where, you know, you're going to need it for sure. And really, you don't realize that you've needed it all along, because that should be the basic foundation you're operating your life on anyway. Equity and righteousness, creating righteous titles, moving them in righteous manners. And you would be able to avoid the pitfalls of the DC realm if you'd have known equity. I guess that's the great spiritual awakening that's happening, where the Holy Spirit is moving upon the waters of the earth, opening the minds of men that can hear.
Well, I just wanted to say thank you, because, you know, I've been studying a while, but, you know, you want to do it, you're trying to do stuff, nothing is working, and you keep fishing and you know, nothing is biting, but then all of a sudden the light go on, and then that's what happened to me. And
yeah.
I really appreciate it.
Sometimes you got to cast the net on the other side of the boat.
Yes, sir.
So anything else? Sounds like
No, that's all I had. I'm just excited about the study, and I'm looking forward to continuing moving forward with it, and having the judges to continue to be advocates in equity until we can crack that door wide open.
Yeah, but he who comes in America must be doing equity, and I think that's the major drawback. We got to learn how to live more equitably ourselves, and then in order to ask equity to do something for us.
Yes,
you got to
sir.
recognize that the other party has just as much rights as you do. You got to concede that they have rights and grant their rights as well. You got to love your brother as yourself, and that creates a right that you can get something because you've been giving something. And I'm not just singling you out. I'm just, everybody needs to be, everybody's got room for improvement. Let's put it that way, include myself. We need to look for the opportunity to give, and giving is love. Supplying the needs of others.
Amen.
Especially when they can't help themselves. I mean, this great country, I think, started out that way, but it hasn't ended up that way. So, anything else you want to add?
No, long live equity. Thank you, CW. And thank you for
Always
NTT.
been, always is, and always will be.
Amen.
Okay, well, thanks for coming on, Tyrone.
Thank you.
Okay, anybody? Questions? Star 8?
Hello, Christian. It's Shaka calling from England.
Hey, how are you doing?
Yeah, fine. I'm good. Yourself? You're on fire tonight.
Still kicking.
Yeah. This sounds like a good call. I was just listening, kind of chuckling while you were talking. Yeah, I almost had some problems getting on the call as well. Like the first time I was trying to get in, it wasn't connecting properly. So I don't know if some issues with TalkShoe or with Skype or what. But anyway.
Well, glad you're on.
I wanted to, yeah, I got on eventually. Yeah, I wanted to ask you something about like wearing different hats. Because there's usually a lot of emphasis from people in the group kind of wanting to be the beneficiary or trying to get away from being trustee. But could it be useful sometimes to act as trustee?
Yeah, in a particular situation, I might want to do that. Yeah.
Yeah. Just in certain particular situations, but not generally. Because I'm just thinking
I may want to be trustee for a friend of mine for a particular situation because I have better skills than maybe he does. And I could administer trust better than he does. And I could actually be trustee where he would be beneficiary.
Mm-hmm.
And we may control, I may control an estate for him.
Yeah.
So there may be situations where that could be an advantage to yourself or to somebody else.
Yeah. But doesn't that stray into the dangerous territory of where you could potentially breach your own trust? Like, say...
Well, it might not be my own trust that is being breached here. Although a trust is a trust, but there are many trusts, and there are different, I can be a trustee for one trust, but be beneficiary on my own trust, say.
Yeah.
So the two trusts are different. They don't really commingle.
Okay. hmm What about in terms of like government officials wearing two hats, or CEOs, CFOs, and those type of individuals, or some of them anyway, maybe certain higher ranking ones, at times wearing a private hat and at times wearing a public hat, and
I mean, a private
how
hat,
that kind of
they're a private man and woman just like you and I are, but they're a public official of some office publicly.
yeah.
Well, that again is kind of like that duality we just talked about 2 minutes ago.
hmm
There could be a private
Yeah,
and a public trust.
yeah. Yeah, because I'm thinking about, like you've said on the calls on more than one occasion, how to connect the two realms, but you also said that you don't like to talk about it. So
Right.
I'm just trying to like think about that stuff, try and get some clues.
Yeah, that's like giving the keys to the Ferrari to the 9-year-old.
Yeah, well, maybe I'm a 7-year-old.
Okay, I'm giving you a benefit.
Okay. Yeah. Okay. So, like, if you nominate a trustee in the private capacity, on the private side, on the public side, that same individual could be your trustee on the opposite side.
Here's the question I always ask. Give me the names of the titles to the two realms.
Mm-hmm.
That's the question. If you can answer the question, that's the thing. But I wouldn't have you answer it on this call.
Okay. Yeah. Yeah. Well, most of the questions I have are
you're right or wrong on this call either.
Yeah. Most of the questions I have are kind of regarding that issue, so I kind of I'm not really sure what to ask in that case.
Really, what the private is really it's your time.
Yeah.
Your life is your time, and it's how you use it. And use is a trust.
Mm.
So how did you convert your use, your time? Because your time is your estate. It's your life. Your life is the estate on the private.
Yeah.
How has it been converted? And everything it's been converted into is really yours anyway.
Mm-hmm.
All you got to do is convert it back.
Yeah.
Not under a perfect title. But I don't see how that's possible today without others operating under a perfect title as well. That's really the one thing that I don't think individually can be done. It has to be done as a group. Come back to perfect titles. To merge the titles and terminate the two realms and bring them back together under one perfect title. There would have to be a group that does that.
Would that
can't
mean
happen
doing
on
away
an
with?
basis.
Yeah, because it means doing away with commerce altogether.
Yes, right.
And yeah. Mm-hmm. Okay. So I mean, I suppose it's just walking it backwards. Like
Yeah,
you say, how was my time converted?
The Michael Jackson moonwalk.
Yeah.
And that's what withdrawal and redeposit does, because the withdrawal and redeposit, and the merger and termination, that reverses on an individual say, case-by-case basis, all the issues that come up.
Yeah.
But the issues will keep popping up until you get out of the commercial realm and perfect the title. But like I said, this isn't going to be possible except if a group of us get together to do that.
Yeah. Well, when you say the issues,
enough people up to a speed or a level that they can jump over the hurdles and make the hurdles like an Olympic runner would in an Olympic race.
Mm-hmm.
So there's no use to tell anybody how to do it because I don't see people having the skills to drive the Ferrari.
Yeah.
And it's going to have to take a group of us to do that.
Yeah, well, I mean, I can see that. I mean, just looking at my own development, the things that I've learned, or even just the concept of conversion, for instance. When I mentioned on one of the calls previously, when I was reading that case, and the Hoses case, and it was talking about the conversion there, and it dawned on me when the judge said it's a reasoning process. I mean, it took me that much, kind of meditating on the subject and digging around and reading just to realize something as simple as that. So,
yeah, that conversion has been converted into derivative titles, which are fiction titles, which are certificates of titles. And certificates of titles are just really certification of a special deposit, some kind of res being held in special deposit. It's a thank you very much for your special deposit receipt.
Mm-hmm.
And we call that a certificate of title. But all this is a piece of paper of what you did, a record of your deed, your action, written down on a piece of paper. But yet it represents really just what you did in the private.
Right.
It's a shadow title. And the shadow always follows the substance, the real thing. You can't separate the shadow from the real thing.
Yeah. Okay. You've used this term spillover trust to refer to the national insurance account or social security account.
Security here, what do you call it over there?
National insurance.
National. Okay.
Yeah.
Insurance.
Probably a more accurate description, I suppose.
Who's insuring what?
Well,
who's bonding what?
Well,
who's indemnifying what?
Mm-hmm. Yeah.
Okay, spillover trust.
Yeah.
They're derivatives also.
It's derivatives. Okay. Is there, I mean, you're someone who comes across as a guy who chooses your words very carefully. I mean, you're describing it as a spillover trust. I was looking up this concept of spillover trust. Are you saying that national insurance account, social security account, is basically the assets or everything that you acquire or accumulate or whatever, the titles that you accumulate, which are not covered by the initial pledge of the birth certificate? Is that what it is, spilling back over into?
Could be a portion of it.
Sorry?
If the birth certificate is the main trust, then we're going to take a portion out of the main trust and we're going to put it in, say, Social Security or the insurance thing, and we're going to call it a spillover trust or whatever you call it. And then that is created as another special deposit. It's another derivative upon a layer upon a layer.
Okay. Okay. So, in expressing the trust, if I hypothetically do the birth certificate trust and deal with, say, the Home Secretary or whoever is responsible for managing, ultimately responsible for the birth certificate, then I only need to give notice to the National Insurance Agency administrative bodies and whatnot.
Yes, everything happens according to Gibson Section 65, that's notice, through 71.
Yeah.
Now, not every
71.
is used, but 65 through 71 is basically the how everything is operating.
Okay.
65 is notice, first thing.
Yeah.
71 is waiver.
hmm Okay. I'm trying to figure out who exactly I need to be dealing with. I suppose it's
not because it's the party that is that has the nexus to the office heads.
yeah. Okay.
And that's where an accounting comes in, or a marshaling of assets.
Mm.
And then what's confusing is, well, over here, there's three layers of government. There's the county level, there's the state level, there's the federal level. So we got three mirrors of one another, and they're like mirror images of one another. It's like the birth certificate originated in the county pledged that, although held it in special deposit, pledged it to the state. State put that in special deposit and then pledged it to the federal, and then who knows where the state and the federal and the county where they also pledged and repledged. There's where the different layers come in.
Yeah. Well, again, I think things are a lot simpler over here, so luckily I don't have to deal with all of that. Yeah. I mean, I suppose, who you want to deal with just depends on what exactly you want to do, isn't it?
Yeah.
Yeah.
And then it's knowing how it's put together, how it's functioning, who to notice.
Okay.
What I find very interesting, which maybe you can appreciate, when Obama was first became president, he had a meeting with the Queen.
Yeah.
And there's a YouTube video, and I forget where it is, but what it was entitled. But anyway, it was both of them giving a toast to the special relationship. And that's what
I've seen that.
Now, unless you've been NTT and know about special deposit and special, how we, talking about special is a different code, you would never understand what they were really talking about.
Mm.
They were talking about the trust that is established between the two countries.
Yeah. I have seen that, and they kept emphasizing the special relationship, with the key of everything they were talking about.
Yeah, more than once.
Yeah. And like you say, because of this study, I could see what was going on. But without this study, I would, it just sounds like normal conversation.
Uh-huh.
So, yeah. Yeah. What else have I got here? Okay, I had quite a few questions that I can't really ask. Kind of all about how to put the two realms together and whatnot. So I'm just gonna go away and think about that a bit more.
Yeah, you want to know how to operate without money? I'll tell you
Yeah.
how to operate without money. You seek first the kingdom of God and all his righteousness, which is equity, and then all things will be given to you. You know, I use the scriptures a lot. And
Yeah.
did Jesus operate with money? No.
No.
When he had to go pay a bill, how did he pay a bill? In other words, how did he pay his electric bill? How did he pay his gasoline bill? How did he pay for his food? He is the prime quintessence example of how to live in the private. But yet he was in lack of nothing because God gave him all things. When he had to pay the tax, how did he pay the tax? The paying of the tax bill was exactly how you would pay any bill. Go fishing, you pull up the fish, you open the fish's mouth, and you take out the coin that's in the fish's mouth and go pay the tax.
Mm.
How did he feed himself and others? With what they had 2 loaves and fishes and the bread that they had. And it was multiplied up miraculously to feed the 5,000, the 4,000. There's that all things. If we seek first the kingdom of God and all his righteousness, all things will be given unto you. We don't need money. Although if money is necessary for some particular purpose, God will supply you with the money out of the fish's mouth. But yet the greater focus on everything is on the money. How do we get the money? How do we get the account? In reality, we have a fiction currency that is worthless. But yet we all want worthless money because we think it buys our meal ticket, and it doesn't.
Mm.
What the most important thing is to live in equity. And then all things will be given to you. And nobody is thinking on how to survive without money. You know, Genesis 3 points out to Adam. He says, man, you've been given all the seeds of the earth for food. Do we plant seeds today? Now, that could be both literal and figurative.
Yeah.
But we don't plant any seeds in the ground, nothing's going to grow. And if we plant the right seeds, we're going to get grapes and corn and fruits and vegetables. And I think you and I can survive on those things.
Yeah.
If we plant rabbits in the backyard and pens and we raise chickens, you know, we don't have to turn into farmers, but maybe we need some people who would do that as a group. And when they did, and everybody share with one another, you know, you grow rabbits, I'll grow chickens, and somebody else will grow fruits and vegetables, and I'll give you what rabbits I have, and you give what chickens you got, and he gives what vegetables he's got, and none of us will starve. Now we've got substance, and we're operating in substance, and we don't have to rely on the grocery store, and we don't need money. All we need is the seeds planted. And what do you plant seeds in? Ground, the land, and you've been given freely the land. You've been given the seeds freely.
Yeah. Yeah.
More blessed to give than to receive. I would make sure that I was being blessed by what I received, by what I gave, because that's how it controls my account. Philippians 4:13 says the principle of God's kingdom works on giving to get, in a way. You're blessed by giving. And when we give, that's what fills your account back up. He was talking about Epaphroditus, that he was given many things to Paul in jail there, and his account was blessed. And he said, not that I received it, he said that it was to your account that you gave. And that's how you fill your account up. But everybody looks at it like you've got an empty basket and you can't feed 5,000. Only because you're not applying kingdom principles in equity. Because he saw a group of people that were there too long and he had to feed them. But he charged the apostles, he says, you take care of this. And they all looked at one another and scratched their heads and their butts and figured out, where are we going to get the money to go feed 5,000 people at? And he said, okay, well, all right, I'll take care of it then. What have you got? Oh, we only got 2 loaves and some fish. Okay, put it in the basket. And he fed all those people. But, today, as well as back then, the kingdom of God works daily, hourly, and minutely on miracles. Because everything God does, he just speaks the word, and it miraculously comes into existence, manifestation of his will. So the normal kingdom principle is miracles. Man cannot understand that. The world can't understand that. But that's the transformation of the mind. Romans 12, 1 and 2. That's by the mercies and graces of God, that when you transform your mind under the understanding of how the kingdom of God operates, in its equity and its righteousness, in application in your life today, that's when all things manifest themselves in your life that you need.
Yeah.
That's the message. Repent, kingdom of enforcement is near. Repent means have an attitude change, a new reasoning skill in your mind. Change your mind. And they're different time shift. Because the kingdom has already been established. But its enforcement is near. And the time is short. Because now's the time for bearing good deeds. Not to be conformed any longer to the pattern of the world, which is based on money, power, and sex.
Yeah.
God of the golden calf, the god of Moloch, the god of Ishtar. So, seek first the kingdom of God and all his righteousness, and all things will be given unto you. For man does not live by bread alone, but by every word that proceeds out of the mouth of God.
Mm-hmm.
So, anything else?
No, I'll leave it there. I'll keep seeking righteousness. That's how I ended up here. So, yeah. I'll leave it at that then. Christian, thanks, yeah?
All right. Have a blessed week.
Oh, okay, you also. Thank you.
Thanks for coming on. Okay, star 8, anybody? Question? Star 8? Who's next?
Good evening, Mr. Walters.
Hey, who's this?
This is Dan. I'm on my cell phone. That's why I sound different.
Hey, Dan. Hey.
Hey.
How are you?
I'm doing fantastic. How about yourself?
I can't complain. I'm still kicking.
It doesn't do any good if you do complain, so. Let me try and get out of the wind here, bud. All right. I'm outside.
I'm Burnham of Eden will be restored 7 times over.
Amen. Amen. Well, I'm off location. In other words, I'm in my home state here with my family all around me. I had a hypothetical situation I had to take care of today, which dealt with a court, and I figured I would call in and give my success story, which is, purely hypothetical. It was as I've spoken about before on the calls, it was a child support modification. Last week there was a withdrawal redeposit filed. The first questions out of the judge's mouth were about the notice of the withdrawal and redeposit and what that was regarding. So I told the judge that, I just want this court to understand that I'm withdrawing from the at-law jurisdiction and redepositing into the equity jurisdiction because equity has more of an ability to rule on what is fair, just, and right, whereas the at-law jurisdiction causes a conflict between the two jurisdictions. And the judge was actually a little short with me. He's like, I know that. Okay. He's like, is that all you wanted me to know? Yes, sir. He's like, well, I already know that, and all you have to do is ask me. Okay. Well, Your Honor, all my research before, I've never found where a lower district court actually has an equitable power. He's like, well, I'm sure that if I was to go and talk with the panel of judges the next time we're having a meeting, if I was to ask them if they know that they sit as a court of equity in a divorce case, I'm sure they would all know it. I'm like, okay. Hi, my name is Dan. I'll be here all day. So, the other side was asked to give their opening statement, which was done. I gave my opening statement, which kind of rolled into a bit of a testimony, all hypothetical, of course, sworn in, and then proceeded to present evidence. The other side had none to present. All they had was verbal, which for those of you out there that have not ever done a court case themselves, you got to present the evidence, because just like Dr. Graves, I think his name is, for jurisdictionary, says that, the preponderance of evidence is what's going to help beat. You can't just rely on verbal.
Yeah, the SOIs and support, the NOIs.
Bingo. That was, what was his name?
Graves?
Dr. Walters. That's right. Yeah, Dr. Walters, NOISOI.
Oh, that one. Yeah, okay, yeah.
So, I presented the evidence. There was no objections to any of the evidence presented. I had 3 main points, 3 hypothetical main points, which, yes, ladies and gentlemen, major equity was working off of statutes. But the main argument was the spirit of the statute today. I had one statute that I wanted to be enacted, actually the spirit thereof, I should say. I wanted all of the children, for both parties, common and uncommon, to the prior marriage, recognized, and attorney's fees to be responsible by each party. The judge listened to everything that I had to say and asked the lawyer if he had anything to rebut Every time I presented a piece of evidence, the lawyer was too busy talking to his client and really didn't care. He's like, whatever, yeah, go ahead, it's a minute, fine. At the end of my statement, I sat down. The lawyer stood up and said, basically, the only argument they really had was whether or not the statute, now keep in mind, he's coming from the letter of the law, not the spirit, the statute, whether or not the statute was actually saying what I implied it to say. Long story short, the lawyer and the judge went back and forth for quite a while, a good 4 or 5 minutes. While you're there in the heat of the moment, it feels like hours. And the lawyer was doing his best to wordsmith, literally, ladies and gentlemen. He was wordsmithing things to try and confuse and throw off. The only thing I can think of was me. Obviously, the judge was keeping right up with him. But at one point in the judge said, so, Mr. Torgus, if I understand correctly, you think that normal parent time is described by statute? Well, yes, Your Honor. And I'm thinking to myself, no. Normal parent time is what's fair, just, and right. That's equity. That has nothing to do with the letter of the law and what's written down. The letter of the law is the bare minimum, the strictest, the least amount, the bare minimum least amount, not what is normal. But I didn't say anything. I didn't object. I kept my mouth shut, and I let that judge work. And I'll be darned if he didn't come full circle and say, well, Mr. Torgerson, I don't see anywhere where the statute actually defines that normal parent time, where the statutes actually define normal parent time. Because, keep in mind, the statute was for a reduction in child support for extended parent time. And that's what that's what the judge was trying to get out of the lawyer, was the definition of extended parent time. Lawyer came up empty-handed. He couldn't come up with crap. Guess what my judge came up with for me? He came up with a definition out of the statutes of what extended parent time is. And guess whose side it was on? Mine. The judge was working for me and with me. It was completely different than the first time I went before this man.
And what was that about?
That was the original divorce, the original setting of hypothetically, the original setting of the child support.
Which happened prior to you knowing NTT?
Absolutely. That was back in 2007, before NTT was even born.
Okay, yeah.
Sorry, 2009. Oh, September 2009, not 2007, September 2009. NTT wasn't born until November of 2009.
So that was purely illegal on the first one then?
Yes, that first one was purely illegal. Absolutely purely illegal. I had zero idea. Now, I was heavily involved in my case because I knew it better than my lawyer did, and I understood that, but I had zero idea of how the court operated. I had no idea that there was rules. I had no idea about trusts. I had zero idea about equity. If you asked me back then about equity, I'd have said, the equity in my house I'm currently buying? Nothing. So, those are all minor successes in NTT all the way up till now. Just the knowledge that I have gained by studying NTT or staying with NTT for the last 4 years is I know enough to be able to go into the courtroom myself. Am I nervous? Hell yeah, I'm nervous. But you know what? Once you study this stuff and you know this stuff and you got Lisa over there drilling it into your head, no, it's not statutes and codes, it's equity, you start to automatically talk that way. You start to use verbiage in the court when you're nervous that you don't realize you even have in your head. And it's all due to this study. It's all due to staying focused. The judge, surprisingly enough, was a little bit irritated that I put in that notice. He's like, I know I sit in the court of equity. Now, was it statutory equity versus ancient? I'm a little confused right now myself. I didn't see that judge actually rule on statute today. He ruled on what was fair, just, and right. He took that lawyer through a circle and brought him back to, he literally said, but in the situation of this family, talking about my ex-wife and our 2 kids, hypothetically, in the situation of this family, I think it is this. That's not statutes and codes. That's conscience, period. And in fact, at the end of the case, after he ruled everything in my favor, I got the child support reduced. I got the statute, the spirit of the statute, mind you. I'm going to come back to that in a second, so keep that in your minds. The spirit of the statute was ruled in my favor. The attorney's fees was a non-issue, not a big deal. But after that was all said and done, that judge started asking me questions about equity. Where did equity originate from? We went back into England. Well, Your Honor, it originally came from when the king actually gave, essentially gave his conscience over to the chancellors to be able to rule, because the common law courts couldn't give a full justice. Now, did I say it just like that in court? No. Was that what I was thinking and trying to explain? Yeah. Was I nervous as all get out and I couldn't get that to flow out as freely as I could right now? Yeah. But when I said the chancellors, he said chancery. And I said, yes, thank you. He said, did you get this from some guy off the internet? And I was like, oh my God, does he know Christian? I was like, no, sir, I got this out of the books. This is what Justice Pomeroy has stated. This is what Justice Story has stated. This is even what's in the Utah statute. Whenever there's a conflict or a variance between the rules of equity and the rules of common law, the rules of equity and the rules of common law, the rules of equity shall prevail. So this is my study. I said even Mr. Bouvier said this. He's like, okay. So it was a test at the beginning and then an interest at the end. My opinion for this judge has completely changed. This man knows what's going on. He understands. The spirit.
That was family court, though, really. So.
That was family court, yeah. And I found several cases that state, a court or a divorce court. According to Utah law, a divorce court sits as a court in equity. Now, they're all older cases, but that doesn't mean that it doesn't have any power. Hell, the ancient equity maxims are ancient, but it doesn't mean they're without power. So, now the spirit of that statute I was talking about, when that lawyer and the judge, hypothetically, were going round and round, that the judge was trying to get out of the lawyer what his true argument was. He said that, the defendant has not actually petitioned the court to modify the child visitation arrangement and blah, 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 blah. And when I got up there, I was like, no, I don't want to modify the child visitation arrangement. And I said, this is where I would object, because this is where the conflict or the variance comes in. The conflict and the variance comes in. He's talking about the letter of the letter of the law. I didn't say it exactly this way, but that's what I was thinking. But I'm talking about the spirit of the law. No, I haven't filed a modification to the child visitation because I don't want the state any more involved in this relationship than it has to be. Mom and I have been able to, hypothetically, to come up with a visitation schedule that works for us, so there's no need to. But the fact of the matter is when I do exercise my extended parent time in the summertime, I'm sending all of the child support to their mother when the child support belongs to the child, which has been founded by the Utah Appeals Court and the Supreme Court. I didn't say it at that time because I'd already made the claim. They stated the case site. Now, I did state case sites, but they were equitable in nature. They were talking about equity. Coming back here. When I have these children for 3 months out of the year, it hits me, and I would like to be able to take them to Carlsbad Caverns or go up on the mountain. I'm not looking to line my own pockets here. It's it's in the best interest of the children. And the judge looked at me, this is like the second time I've made this type of spiel. He's like, I understand. Okay. So I was ruling out the spirit. The spirit of the statute was, hey, extended parent time. You should not have to send, $1,000 a month back where they're not at. You should be able to keep half of that and enjoy it with them. Yeah. And at the end of the day, that's what was found to be fair, just, and right. And that's what was ruled on. And I think it rubbed the lawyer a little bit of the wrong way, hypothetically. So there you go.
Okay. Bingo.
Yeah, I would say so. Was it a purely equitable case? I don't know, Kristen. It was definitely at least three-quarters of the way equity, because even though they started talking about statutes, and when the judge finally made the ruling, they said, and Mr.
Well, let's put it this way, say that family court in that particular state functions as equity.
I would say yes. And if you have somebody that is, like me, I'm not tooting my own horn here, but understands and can offend and defend the position and prove it to the judge, I think you got it pretty much in the bag.
That's what I was going to say. If we take that and use that as a model, and if we model the spirit of everything as being equity, and maybe we apply it to different forums, say like your regular state court, then, we may have some different results, as you had the same results in family court in that state.
Right.
So, again, the spirit of the law instead of the law itself.
And the conflict. The conflict. There was one point in time I got up and I hypothetically, I quoted the statute, 6434 or whatever it is. I can't remember right now because I'm celebrating with an adult beverage. What you kind of
bring forth tonight is what, Lisa and I were talking about earlier today, was the conflict. And it was brought out between the two of us that really the conflict is the meaning of the statute, and the meaning of the statute is not in the statute itself. It's in the annotated versions, the explanation of the statute.
Or and maybe even your own self-interpretation of the statute.
Well, yeah, the way the statute is interpreted is in the annotated. And the annotated is separate from, and not the same writing as the statute itself that's codified. So you read the literal codification, but if you want to know the meaning of it, what it's really doing, you got to go to the annotated. But the annotated is not codified with the statute. Now that's the conflict. Because if you read the literal statute, it could be interpreted as being one thing under a narrow view, but then if you read the annotated, which is someplace else in another book, it's not codified, but it explains the code. And it has a different meaning. There's where it talks about equity. And that's a conflict. And isn't that what you said the judge understood to be? The spirit of the law?
Yeah, he seemed offended.
What?
He seemed offended that I put that notice in there that, under Utah law, a court of equity sits as a court of, divorce court sits as a court of equity. And, I had quotes from Pomeroy, I had quotes from Mr. Bouvier in there, and he's like, is that all you wanted me to know, is that I sit as a court of equity in the divorce court? In this setting, yeah.
That's
like I tell you with the whole thing, but...
Yeah. They probably don't want that to be publicly known.
Either that, or he was acting like he was irritated to test.
Oh, that could be too, yeah.
Yeah, and I came up, and at the very end, Christian, He's like, so where'd you get this stuff off of? The internet? Some guy off the internet? And I was literally like, oh my God, does he heard of Christian before? I was like, no, it's in the old books. This is what Justice Story has talked about, what Justice Pomeroy has talked about, even Mr. Bouvier. It's in the ancient books. And he was like, all right. He's like, all right. And Christian, he was talking to me like you and I talk to each other right now. I was flabbergasted. It was amazing. And he ruled completely in my favor. Equity follows the law. And that's what happened.
Yeah, but equity, its understanding, really departs from the law.
Yeah. Well, I was literally talking in the parable there, so.
If it's not equitable, it departs from the law.
I even at one point in time during the conversation back and forth, I said, he who seeks equity must do equity, and that's equated to the golden rule. And he's like, yeah, I remember that. And I said, to be honest with you, Judge, in my opinion, that's the law that's written on your heart when you're born, about the Ten Commandments. He didn't say a word. He went on to talking to the hypothetically went on to talking to the other side's lawyer. So it was very good.
Well, glad to hear that.
Yeah. So there you go, my friend. I've got my mom and my sister and all my family inside, so I better get off the phone, go back in there and visit them, and I'll have to talk to you about this next week, I guess, further, if I remember anything else.
Yeah, we don't tout wins, but hey, there are wins.
Yeah, and it all depends on what your definition of a win is. In my opinion, there was multiple wins today. Not only was I able to go down there and get what I wanted out of the court, but I was able to go down there and get what I wanted out of the court myself. I didn't have to ask the lawyer to help me do it. I did it. It's multiple wins today. A win is not just defined by how much money you get. And that was not my focus today in court. It was what's fair, just, and right for these kids that are involved. And the judge saw that. I guarantee he saw that. He who seeks equity must do equity.
Yep, well, congratulations.
Thank you, Christian.
He's paying off, huh?
Yes. I thank you for everything that you've done for free, selflessly. Thank you. I owe you a cup of coffee.
I like cappuccino.
All right. I owe you a cup of cappuccino then. All right, sir. I'm gonna bow out and go visit my family. So.
All right.
Love you. God bless you, and I'll talk to you soon.
Okay, Dan. All right. Appreciate you coming on. Thanks.
Absolutely. No problem.
All right.
Bye-bye.
So anybody question? Star 8. Anybody question? Press star 8 to raise your hand. Who's next? Nobody? Star 8. It's Clearboard. Star 8. Anybody question? Star 8. Anybody question?
Hello.
Yes. Who's this? Hi.
Hey, Kristen, it's Cynthia from Chicago.
Hi. What's going on?
Don't have much of a question this evening. I ended up answering my own questions through study, so that worked out for me this week. I did want to let you know that when I went down to the library, law library, I was told I did ask for both the federal and the state copies of the CJS, and he was unaware of there being two, or separate, I should say. But he did walk me through how to look up some cases, so the minute I get a chance to get back down there, on the Westlaw computer there. I can.
There should be a state version of the state jurisprudence, and in that multi-volume series.
Yeah, he walked through the book with me, particularly the one that I was looking up and everything, and he could not tell, was unable to, kind of delineate from the state and the federal.
Oh, well, the state one's all state. The federal's all federal.
So I guess my question is
different. Federal set of, say, 50 volumes and a state volume set being, say, 50 volumes, but they're not the same.
Yeah.
They're 50 volumes each or more. But there's a state set of state jurisprudence, and then there's a federal jurisprudence.
Okay. Well, when I go back down there, he said he did say that he would help me out to look for. But practically where he pointed me to, and one of the reasons that he pointed me to this section is because they're moving all of the older books. Mm-hmm. They're doing a full scale, like a rehab of the entire library, he told me, and where they're moving out a lot of the books. And he also told me that most of the attorneys aren't allowed to some of the older books, aren't even allowed to see the older books. Without some express permission or something like that. But scholars, if you're a scholar, then you can just walk right in and request those reference books and take them out if you
figure out what are on their index that there is not allowed to be seen by except special people.
He did say that they are being indexed, but in a separate particular. He was making a big point to say and to show that these things are going on, like you won't be able to find it, publicly. That's what he was trying to.
Out to the public, or?
I guess they're going to be on, from what I can tell, practically if you know what you're looking for, then you can come in and request that particular one. In other words, they're not going to be on the shelf, readily available, because I found a whole section on a lot of the appellate cases, numbered and things like that. But those, as I was looking them up, those were the ones that were being carted or put on a cart, rather, to be taken off to a different section.
Mm-hmm. Like some of the libraries I've been into, they have a special section that's usually locked up, and you can't get in there unless they let you in there. And then you can't take anything out of there either.
That's where he took me to.
Yeah, right.
Yeah, that's where he took me to. He had to walk me through to get to that part. Yeah, he took me there. And so, but he did say, anytime you want to go down, if you come down early enough, we can go through and look for some things. I was like, well, thank you. Sure. No problem. So I've kind of finished up what I went there for, making the copies.
But this jurisprudence state version is like, on a different floor back in the main library, but it's the section that's got the most dust on it.
Oh, yeah, these were pretty dusty. And so I guess, what I'm going to do is not only just ask him, but ask some colleagues, because I think it was a particular case that I was looking for that I found in the Chantry books for Illinois. And I think it was called Reports on Illinois. That's what it's called, a particular case. Uh-huh. And when we looked up the case, the sections, he took me to the sections, showed me how to find it, that's written on the outside of the book. He took me there, and we couldn't find that particular one. He was surprised that it was labeled that way, in the manner that it was labeled. But he did show me where it should be. So I was able to find all of those. Didn't get a chance to look through them, but I did find them. Mm-hmm. So, it's a step in a direction where I didn't know where to go before to now I know where to go.
Right.
Yeah, and to look up particular cases.
But there should be a separate state volume that's the state jurisprudence, and then in one of those or several of those volumes should be the equity section.
Now, when you say the equity section, such as like the one that I went down to get copies of was the 1A, Book 1A, Actions.
Yeah. Now, all those different numbered books, they
Mm-hmm.
represent a different phase of the law or a different explanation of a different jurisdiction or forum,
Mm-hmm.
But just like corpus juris secundum, the book in equity, I think, is, what's the volume number, 50?
Oh, I don't know. Volume 50?
Example. So it's like 1 or 2 volumes and like 75 volumes of the federal jurisdiction, corpus juris secundum, but there's only like 2 volumes of equity out of the 75.
Mm-hmm. Okay.
So on the state version, let's say the state version has 50 volumes, it may be 1 or 2 volumes in one of those 50, only pertaining to the state, though. It'll be a state equity jurisprudence.
Yeah, it didn't say like in the beginning of the book. It didn't say it didn't state or federal, and I guess that's what he was looking for.
Might be listed as chancery.
Okay. Oh yeah, I found a whole chancery section, so that's where I'm going to start when I go back down there. It's a whole chancery. Besides the reports on chancery, it's a whole nother chancery section.
Mm-hmm.
So I had fun, needless to say, to know to go down and be able to look at that. I had another question. This is a question. I was paying attention to the section that we read today, especially where it mentioned about the trustee having the duty of creating securities.
Right.
And the mortgage deed itself is definitely listed as a security.
Yeah. It's a derivative.
And I was noticing how they had the borrower as, let's say, if I was to borrow, they would list me as, putting the name, all cap name. And then they would use a comma. And then they would use a married woman. That's how it would be, kind of delineated. It's kind of interesting that it was, with the comma. It gave me the impression that they was naming 2 different things there. I could be wrong in my thinking on that one.
Well, they're kind of like in a survey.
But on when they were listing the lender, this one had the MERS thing on there. So they listed the mortgagee and the lender, and they were sure to say a corporation.
Yeah, a survey creates a title.
Okay.
So they got to put down, length, breadth,
right,
color,
right.
Some way to delineate the specific thing so that they can identify it.
But okay, as far as that's
married
definitely
woman. That's an identifier.
So this also would create, or this would equal, I should say, a statement of interest. This would equal a record.
Survey creating a title, a record. So it's kind of giving you a model how to create a title.
Wouldn't this be a fact of a statement of your interest?
Yeah, I can move titles.
And the only seal that's on there is my seal.
Yep. You got the signet ring.
Yeah.
You're the key. You're the king.
Yeah. Because I noticed on the supposed note that follows, or supposed to be attached to it.
You're given the authority to create a derivative or a security.
Yeah, it's an order.
Yeah.
It's an order. That's part of the process of, the operation. But I think the key for me seeing this is to look at how one is to operate under trust in knowing that an order was given. Because you have the receipt, and they definitely say, in that language.
It's an order to move a title.
Yeah. And then it goes on to say, for a note I have received. That's definitely a receipt. they have that language in there, and I'm thinking on that language, but that's definitely saying that this is the receipt. But the receipt, or the way that we looked at it, was alleging only on their accounts, and we never, as beneficiaries, part of our duties is definitely to keep a ledgering on our side as well.
As a trustee, yeah, that's required.
I mean, how are we going to give orders to the trustee if we're not keeping an account, if you will, of our own?
Well, that would be more like, say, the grantor using that office as to set the trust up, or whatever you put it in the indenture, and to how much power you gave the beneficiary.
Okay.
Because the beneficiary could be totally not knowing where anything comes from, but yet he's the beneficiary of the trust. And he really doesn't have to know. It's like in England in the old days, there were benefactors that were taking care of people, and they were unknown to the people where the money was coming from.
Mm-hmm.
So it's kind of like the same thing. The beneficiary doesn't have to know, but the grantor would have to. Now, if the grantor was the same person as the beneficiary, one of the co-beneficiaries, then, that would make a difference.
Well, the grantor would be the one at this, the way that you just explained this, the one that sets the value for everything. I was reading that section actually is before Section 65 in Gibson, this Section 64 that goes into points on, I guess it would be considered points on the notice or the record. Mm-hmm. And one of the points, point 33 actually, it says that the value of anything is estimated according to its worth in money.
Now that's legal. That's legal, but...
That would be considered legal?
Yeah, because you're putting a dollar amount on it, which puts a limitation on it. And limitation is at law. Unlimited, which would be its trust res, and has an unlimited value.
Well, I was looking at, the reference you made about when Jesus gave the order, if you will, to go to receive the 2 coins from the fish. Mm-hmm. It was enough to handle the matter or, I guess, balance the accounting because according to them, they have this, big what you owe side, and then your side is to handle the accounting.
Right.
And so the species of money.
Yeah, now keep in mind before that, just that paragraph before that, he was talking about, is it right that the tax should be paid by the heir?
Mm-hmm.
And he said, no, well, the heir is not liable.
Yes, definitely making a distinction.
But he said, so we do not offend them. Go into the fish's mouth and take the coin and go pay the tax.
Mm-hmm.
Although it's not necessary, just to keep everything cool, we won't agitate them and we'll give them what they want. Because today is not the time.
Mm-hmm.
The heirs haven't become the kings yet.
Okay.
But when you become the king, then you are no longer liable for the tax. Because you're an heir. And heirs don't pay tax.
I guess my question is that, and I know you said it before, it's like don't create the debt in the first place, but,
Yeah, I know. There was, Winston gives an example. The guy talks about, every time I do this with my arm, I raise my arm hurts. And he's explaining that to the doctor. And the doctor looks at him and says, well, don't do that anymore. If it hurts, don't do it anymore. So we come into the outlaw realm and we get beat up and it hurts, but then we keep on going back and trying to, get beat up again.
Mm-hmm, mm-hmm.
So, but if you don't like getting beat up, don't go there anymore. But then it's, okay, well, what do I do otherwise? How do I eat? How do I live? How do I pay my bills?
We have to use the species of money until our knowledge increases.
Yeah, until we figure out how the kingdom operates.
Yeah.
And the kingdom operates by going to the fish's mouth and multiplying up, and God provides all. But the key is whether or not we're doing equity, to receive equity. And I think that's the great spiritual awakening.
It's interesting that you mentioned to a certain degree we're going to have to get to the point where it has to be done as a group. And I cannot recall some document I was reading in the last 2 days. I'm reading too much or something, and I can't recall that. And that thought came to me. I said, this thing has to be done in a group.
Class of beneficiaries.
Yeah.
So, anything else?
No, that's it. I appreciate it. That's all I have for today.
All right, so interesting stuff there.
Yeah, I can't wait to get back down there. Probably should be able to hit it at least Monday and Tuesday, 2 full days. So we'll see what happens.
Yeah, well, I was asking, pertaining to the call, I was saying what you brought out.
Oh, okay. All right, Kristen. Talk to you soon.
A few more times. Got some good questions. It's kind of like the dialogue between, the dialogue brings out certain things. And when you have somebody that comes on that can ask the right questions, it helps to bring out the real thing. So I thank you for coming on.
Thanks, Christian. Appreciate that.
Okay, who's next? Nobody? Oh, open board? Okay. Star 8, anybody? Questions? Star 8? Anybody? Questions? Star 8? Raise your hand. Get in the queue line. Anybody? Question? Star 8. Going once? Questions? Anybody? Star 8? Star 8. Anybody? Questions? Going twice. Star 8. Anybody? Questions? Press star 8. Last call. Anybody? Question? Okay, that's it. No, we'll call it a show. So I'd like to thank all those that came on. It was an interesting night. Yeah, it was good questions there. So I appreciate them, and we'll see you next week, same time, same channel, and everybody have a great week. Be blessed. Night all.